This episode of Legaleagle was made possible by Skillshare. Learn to think like a lawyer for free for 2 months by clicking on the link in the description. Democrats on the House Judiciary Committee have now decided on the language of 2 articles of impeachment against President Trump. Is the president's conduct really impeachable? Is this a political charade? And are Democrats stepping out of line by drafting these 2 particular articles of impeachment? Well, to figure that out, we have to look at the only 3 other times this has ever happened. Let's compare President Trump's articles of impeachment to Presidents Johnson, Nixon, and Clinton. Hey, Legal Eagles, it's time to think like a lawyer because we are living in very interesting times. Today, we're going to talk about how impeachment works and how and when you're allowed to throw a president out of office. Why are we talking about impeachment right now? No reason, just seemed like a fun thing to do. So let's start at the beginning. Where does impeachment come from? Impeachment is a process that lets Congress remove federal office holders from their position when they do something wrong. Where does this idea come from? Well, like most of the things that relate to the law of our country, it comes from England. Impeachment was a process that Parliament used to limit the power of kings and queens. Since they couldn't impeach the royal family, English Parliament would impeach the king or queen's ministers and favorites. Basically, anyone connected to the crown who had amassed too much power and used it in inappropriate ways. If someone abused their power, neglected their duties, misused funds, encroached on Parliament's power, or betrayed the nation's trust, they could be impeached, which often meant they were thrown in jail. Parliament referred to these issues as high crimes and misdemeanors. You'll probably recognize that phrase in the US Constitution. High crimes and misdemeanors in English law referred to offenses against the country itself and not necessarily criminal offenses per se. So fast forward to the American colonies. The American colonists were not entirely happy with the way that King George treated them, so they started effectively impeaching colonial officials who reported to the crown in the American colonies. This was a risky play since colonial governments technically didn't have the legal right to impeach anyone. Since the colonists didn't have the power to subject officials to criminal penalties like prison, the penalty for impeachment in the colonies was for the office holder to be removed from office. When the English crown warned the American colonists to stop the impeachment proceedings, eventually that was one of the factors that led to the breakup with the English monarchy entirely. That's why the Declaration of Independence is part breakup letter, part burn book, and part impeachment notice. The Declaration lists grievances against King George and insists that Americans have the right to fire him. After the Revolutionary War, 8 of the original 13 colonies added impeachment power to their state constitutions. When the Constitution was ratified, it included this important tool found in Article 2, Section 4. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. So how does impeachment work? Article 1 gives the House of Representatives the power of impeachment and the Senate the power to hold an impeachment trial. The House of Representatives acts as the prosecutor, bringing formal charges against the federal officer or the president, while the Senate holds the actual trial itself for impeachment and removal of office. For a person to be convicted and removed from office, 2/3 of the Senate must vote to convict. Removal from office is the only penalty which can result from impeachment. This brings us to the most important question of all. What actions can get a federal officer impeached? Technically, the answer is found right there in Article 2, Section 4. A person can be impeached for treason, bribery, or other high crimes and misdemeanors. The problem is that language doesn't really give us the guidance that we need to figure out what specific actions are required to remove someone from office. But the first 2 criteria are easy calls. If a public official commits treason or bribery, he or she is obviously acting on behalf of another country or for the direct interest of themselves over the interests of the country, which makes impeachment a relatively easy call. It's generally the other requirement for high crimes and misdemeanors that causes all of the vexation. So what is a high crime or misdemeanor? The term isn't defined in our law or in the Constitution, so we have to define it first by stating what it is not. The Founding Fathers were concerned about offenses committed against the country itself by people in high places of authority. Therefore, the term high crime probably doesn't mean necessarily a high felony like a murder or kidnapping. Instead, the phrase probably implies a crime by a person in the government in a high place of authority, just like it did in England against the people who were surrogates for the Crown of England. We also know that high crime can't mean a very, very bad felony or crime because it's paired with a misdemeanor. The Constitution also says a public official can be impeached for a, quote, misdemeanor. In American criminal law, a misdemeanor is a crime punishable by less than 1 year in jail. Misdemeanors are crimes like petty theft, possession of marijuana, disorderly conduct, and public intoxication. You know, all the fun things. If we use the standard legal definition of misdemeanor in criminal law, then that would expose federal officials to removal for really basic infractions. But is that really what the Founding Fathers were after? Probably not. Contemporary writings show that the founders probably understood misdemeanor as a way to punish, quote, malversation in office. Malversation is an almost obsolete word, but it basically means corrupt behavior by a person in a position of public trust. Now, I can almost feel your frustration right now. If there isn't a list of high crimes and misdemeanors to go off of, where do we turn to next? Well, the best resource we have is precedent, and we can examine how impeachment has been used in the past. So let's talk about first non-presidential impeachment. Impeachment has only been used 17 times against officials of lower rank than president. No one has been impeached for treason, but 3 people have been impeached for bribery, including 2 judges and a cabinet member. The rest were considered high crimes. These cases fall into 3 categories. The first one is for people who have used the office for improper purpose. This usually means things like taking bribes or kickbacks. The second category involves things like exceeding the constitutional bounds of the powers of office. Most people who were impeached for abuse of power have been federal judges. Their problematic actions include things like showing bias towards certain litigants, abusing the contempt of court powers, and imprisoning lawyers who were critical of the judges. The third category is reserved for conduct grossly incompatible with the proper function and purpose of the office. This includes incompetence or moral failings that may not be illegal, but which sully the office. For example, a few judges were impeached for being drunks who ranted and raved from the bench. I've certainly never been in front of any judges who acted like that at all, and all of the judges that I've been in front of, especially the ones that voted for my client, were upstanding citizens. Now, moral failings have also been considered impeachment worthy, including groping subordinate employees. This was also done by an out-of-control federal judge. These examples don't exactly set an extremely high bar for impeachment from a behavioral standpoint. Still, there have been fewer impeachments than one would probably assume over time. That's mostly because the decision to impeach an office holder is a serious one, and political considerations also play a role. This is especially the case when Congress is debating whether to impeach a sitting president. So, let's talk about the elephant in the room. What is the presidential standard for impeachment? Well, when Bill Clinton was subject to an impeachment inquiry, his lawyers argued that the standard should be much higher for removal of the most powerful person in government. Although there may be some logic to this argument, you can also argue that the president should be held to a higher standard of conduct because that person is the most powerful person in the American government. To see how various Congresses have interpreted the legal standard for impeachment, let's take a look at the attempted impeachments of 3 US presidents: Andrew Johnson, Richard Nixon, and Bill Clinton. We'll start with Andrew Johnson. The first president to face impeachment was Andrew Johnson, who became president after Lincoln's assassination. The Republicans in Congress at the time strongly disagreed with President Johnson's attempt to stop newly freed former slaves from getting equal rights. Congress even drew up articles of impeachment stating this. However, they got nowhere with this particular argument, and not enough representatives would impeach on those grounds. And during the ensuing power struggle, Congress passed the Tenure of Office Act to try to ensnare Johnson in a trap. The law stripped the president's right to fire executive branch officials without the Senate's consent. The law stipulated that if Johnson violated the act, it constituted a high misdemeanor which Congress would consider an impeachable offense. President Johnson eventually fired the Secretary of War, triggering the Tenure of Office Act. The House drew up articles of impeachment and voted overwhelmingly to impeach on those grounds. Interestingly, since people have focused on the process associated with President Trump's impeachment, here it took only 5 days for Congress to pass the Tenure of Office Act and then file articles of impeachment against President Johnson. The House brought 11 articles of impeachment against Johnson. These are perhaps the broadest articles of impeachment against any president in history, and given the craven political nature of these particular articles of impeachment, probably the most controversial as well. The Johnson articles of impeachment included dismissing Edward Stanton from office after the Senate had voted not to concur with his dismissal and had ordered him reinstated, and conspiring to prevent him from continuing. appointing Lorenzo Thomas as Secretary of War ad interim despite the lack of vacancy in the office since the dismissal of Stanton had been allegedly invalid and without the advice and consent of the Senate, conspiring to unlawfully violate and curtail faithful execution of the Tenure of Office Act and take possession of the property of the Department of War, issuing orders to violate federal law requiring all military orders to be issued through the General of the Army, making 3 speeches with intent to, quote, attempt to bring into disgrace, ridicule, hatred, contempt, and reproach the Congress of the United States, and finally bringing disgrace and ridicule to the presidency by his aforementioned words and actions. But the story wasn't over. The Senate still needed to convict. 35 senators voted guilty and 19 voted not guilty, thus falling short by 1 single vote of the 2/3 majority required for conviction under the Constitution. Now, while this is a gross over-summary, Johnson had a legitimate gripe. The law passed by Congress limiting his powers was unconstitutional. The Supreme Court ruled it was unconstitutional in 1926. But the Republican members of the House also had a legitimate gripe. President Johnson turned his back on Lincoln's Reconstruction Plan because he had an antipathy toward African Americans. So what can we deduce from this particular incident? Well, it's a mixed bag. Johnson and Congress were having a political dispute about the future of the nation, a dispute that would dramatically impact both ex-Confederates and newly freed slaves. Well, you'll notice that Johnson's impeachment wasn't about breaking a criminal law. It's important to remember that breaking a criminal law could be grounds for impeachment, but the president doesn't need to commit a crime in order to face impeachment. At its heart, the Johnson impeachment was a political issue. Both sides really had failed in their oath of office. Both the president was refusing to execute the laws and Congress was passing unconstitutional laws to ensnare the president. And ultimately, Johnson fell only 1 vote short of the vote needed to remove him from office. Which brings us to the near impeachment of President Richard Nixon. So let's review the basics of the Watergate scandal that led to Richard Nixon's resignation. Now, this is really just going to be the basics. This is an incredibly complicated part of American history that I'm not going to do justice, but perhaps in a later video, I'll cover it in more detail. During the summer of 1971, President Nixon was embroiled in the increasingly unpopular Vietnam War. Daniel Ellsberg, a Department of Defense military analyst, started leaking government secrets about the war to various newspapers. The biggest leak was a top-secret report now known as the Pentagon Papers, which was a confidential history of what America had been doing in Vietnam. President Nixon established a team of special operatives to plug the leaks and engage in a number of illegal but pro-Nixon shenanigans. The group gave themselves the nickname the Plumbers. The Plumbers engaged in all kinds of illicit activities, including breaking into Ellsberg's psychiatrist office to steal medical records and supporting a Democratic candidate who Nixon felt he could easily defeat. Nixon's team also planted bugs in the offices of the Democratic National Committee, which were located in the Watergate office complex. They later broke into the offices a second time to fix those recording devices. The FBI eventually caught the Watergate burglars and Congress launched an investigation. Eventually, over a multi-year investigation, the story came out. President Nixon made secret audio tapes of conversations in the White House. He knew about the Plumbers, he knew about the Watergate burglars, and he ordered his subordinates to help cover up those activities. Now, although the malfeasance goes back to at least 1971, a Congressional Select Committee wasn't formed until February of 1973. And during the course of the investigation into the Nixon White House, Special Prosecutor Archibald Cox issued a subpoena for the secret White House audio tapes. President Nixon refused to comply with the subpoena and instead fired the special prosecutor in October of 1973, which is the so-called Saturday Night Massacre. On March 1st, 1974, a grand jury in Washington, D.C. indicted several former aides of Nixon who became known as the Watergate 7. When Cox's successor sought the tapes and Nixon refused, the case went to the Supreme Court. The court ruled in July of 1974 in a unanimous 8-0 decision against President Nixon's claim that the tapes were protected by executive privilege. President Nixon was ultimately charged with 3 articles of impeachment, though it's interesting that 2 articles of impeachment were actually rejected by the House. The 3 articles of impeachment that were adopted against Nixon included obstruction of justice by using his powers of office to cover up the Watergate break-in, abuse of power by disregarding Nixon's constitutional duty to faithfully execute the laws of the United States and administration of justice, and contempt of Congress by disobeying congressional subpoenas seeking evidence that was, quote, deemed necessary by the committee in order to resolve by direct evidence fundamental factual questions relating to presidential direction, knowledge, or approval of actions demonstrated by other evidence to be substantial grounds for impeachment of the president. In other words, disregarding congressional subpoenas about what the president knew and when he knew it. The two articles of impeachment that were rejected against Nixon included usurping the powers of Congress and hiding the fact that the US had bombed Cambodia, and an emolument violation related to tax fraud. So, with the House ready to vote on the impeachment articles, President Nixon resigned before facing the actual formal impeachment. Which takes us into the more modern era. The third presidential impeachment involved President Bill Clinton. During Clinton's presidency, a special prosecutor was appointed to investigate the so-called Whitewater affair, which was not one of Bill Clinton's extramarital affairs, but rather a failed real estate company that the Clintons had been involved in back in 1978. Appointed special counsel Kenneth Starr churned through evidence about Whitewater without finding any serious offense, so he expanded the investigation to include other matters. And in this expanded investigation, Clinton's long history of extramarital affairs and sexual harassment allegations caught up with him. An Arkansas woman named Paula Jones sued Clinton for sexual harassment. During the lawsuit, her legal team uncovered information that Clinton had an affair with a young intern while he was president. The intern, Monica Lewinsky, told her friend Linda Tripp, as part of the expanded investigation, Starr investigated President Clinton's actions to cover up the affair and obstruct the sexual harassment lawsuit. Starr would eventually chronicle all of this information in a 500-page report. House Republicans, on that basis, decided to impeach. The articles of impeachment against President Clinton are by far the simplest, and there are only two, and they're pretty straightforward. The first is lying to a grand jury about Monica Lewinsky, and the second is attempting to obstruct justice regarding the civil case by Paula Jones against President Clinton. On those articles, the House voted to impeach, but the Senate voted to acquit President Clinton, ending the impeachment. So what do we make of all this? Well, Gerald Ford once criticized the impeachment process as meaning, quote, whatever a majority of Congress says it is. He meant that impeachment is a purely political device. And on some level, whether something is impeachable is a tautology. If you have the votes, then it is impeachable. Impeachment is, first and foremost, a political tool. And one way of looking at the Clinton impeachment is that while perjury and obstruction of justice are serious and felonies, the Senate simply didn't believe that President Clinton's perjury and obstruction of justice violations involved matters that gravely impacted the public. But another way of looking at it is that it was simply a craven political move, and there's no rhyme or reason behind it other than that. So what can we surmise from these three different attempts to impeach presidents? Well, there are several key principles. First is that the founders provided a tool that can be used for good or ill. It all depends on the circumstances. The second is that there is a legal standard that is not purely political. The standard for impeaching the president is broad enough to encompass things like treason, bribery, crimes, corruption, and moral failings. But the Senate doesn't necessarily need to find the president guilty of a criminal offense for the president to be impeached. And third, political factors absolutely do play a role in impeachment proceedings. Congress decides whether a president should be impeached, and their decisions are often rooted in practical political considerations rather than legal ones. So what is going to happen with President Trump, and how will history look back on this? Well, impeachment is back in the news because the Democrats appear to be moving forward with formal impeachment inquiries. Article 1 is labeled abuse of power. In that article, the House alleges that President Trump abused the power of the presidency by using the power of his office to solicit a foreign government to interfere in the 2020 presidential election in his favor and for his own personal gain as Donald Trump the individual. He conditioned official acts of the United States government on receiving personal gain and subverting the national interest of the United States, and corrupted the Democratic election that'll take place in 2020. The second article of impeachment is labeled obstruction of Congress. There, the House alleges that the president obstructed Congress's lawful impeachment inquiry by directing the executive branch agencies, offices, and officials not to comply with congressional subpoenas regarding the impeachment inquiry. Effectively, the executive branch, led by President Trump, has completely stonewalled the entire congressional impeachment efforts, and of course, Congress has sole impeachment authority. Now, you can disagree about the merits, but it appears that these articles of impeachment against President Trump are grounded solidly in the foundation of past articles of impeachment against past presidents. Indeed, these kinds of abuse of power and obstruction of justice or obstruction of Congress are exactly the kinds of things that past presidents have been impeached on in the past. From my perspective, it's interesting that the House did not pass a third article of impeachment against President Trump related to bribery. Certainly, acts of bribery are outlined in the first article of impeachment against President Trump, so it's interesting that they didn't go the step further to actually name a specific article of impeachment related to bribery, mainly because there's so much debate about what qualifies as a high crime or misdemeanor for the purposes of impeachment. But remember, bribery is listed as the things that you can impeach a president on, along with high crimes or misdemeanors. So it's interesting that the House decided not to include an explicit article of impeachment related to bribery itself. So what's going to happen to President Trump in the coming weeks and months? Well, President Trump is going to be impeached by the House. That much is certain. That means that he will now be tried in the Senate. Now, I'm working on another video to tackle all of the Senate's procedures during the coming impeachment trial, so stay tuned for that. It's certainly unclear whether any Republicans will vote to remove President Trump from office. But between the whistleblower complaint, the witnesses that testified in the impeachment hearings, and the articles of impeachment, it's pretty obvious that this is not going to be particularly good for President Trump, even if he claims now that it was totally okay and perfect. But it's early in the game, and we still need far, far more facts than we currently have. So when you hear the news reports about the potential impeachment of President Trump, keep in mind that there is no constitutionally mandated timeline for impeachment. It can take years. But also keep in mind that the House of Representatives doesn't actually have to call witnesses or start an inquiry. They could vote to impeach right away if they wanted to and let the Senate handle the trial. So we will have to stay tuned. Now, whatever is in the whistleblower complaint, it's pretty obvious that it's not going to be good for President Trump, even if he now claims that it was totally okay. Now, maybe the president can convince his base that this is nothing, but it will take some really creative spinning of the truth to get there. So if you're watching Mr. President, I recommend you check out creative nonfiction Truth with Style by Susan Orlean on Skillshare. Susan is a best-selling author and longtime New Yorker staff writer, and she walks us through her writing process for transforming ordinary subjects into exceptional stories, like turning a simple phone call with the Ukrainian president into an exceptional story that leads to the 4th impeachment in US history. Skillshare is an online learning community that has thousands of classes on everything like music, design, technology, and business. Legal Eagles will get 2 free months of Skillshare when you click on the link below, plus it really helps out this channel. And it's great for deflecting political witch hunts! The free premium membership gives you unlimited access to must-know topics so you can improve your skills and learn new things, all free for 2 months. Get Skillshare and improve yourself now so you can get a head start on defending your perfect call! Just click on the link in the description. Do you agree with my analysis? Leave your objections in the comments and check out my other real law reviews over here, where I'll see you in court.